Good morning, good afternoon, hello, good evening, whenever you might be watching this video. Apologize for the mess behind me. Turns out unpacking my office, not really a priority for me. So here we are, at the end of the semester, and boy, I just hate the notion of not seeing you guys in person again, but such is life, such is how these things work out. So, a couple of administrative things that I want to bring to your attention. The first one is that I do want to encourage you to make sure that you read the final assignment very closely. And the reason for that is it is specifically intended to answer all the questions that I could think of that you might have. That doesn't mean that I've captured all of the questions that are possible, but I've probably captured a lot of the more common ones. And so, if you've read it closely and the question that you have is still not answered, then by all means reach out. I'm happy to have a conversation. I will admit that, if you ask me a question that seems to me to be answered within the assignment, that's a little frustrating, but, it is what it is, and I'm happy to help if necessary, but start with the assignment. In particular, and I want to raise this because of some things that have happened with your last couple of reaction papers, of reflection papers, you need to be very careful to make sure that what you are writing is responsive to the question being posed in the assignment. Few folks had some issues with writing reflection papers that did not appear to engage with the questions that the assignments posed, and they did not do well on that particular reflection paper. So I want you to do well, I want you to succeed, and so make sure that the question I'm asking is the question that you're answering. Because if you don't, then you're not going to be happy with how you do in the class. So I have some policy issues to discuss with you. As I've been thinking about and putting together this lecture, a few questions have occurred to me that I think are worthy of further attention. They have been posted on D2L as a discussion board. In order to receive credit for attending this class, you have to post a response to at least 3 of the questions that I have posted on the discussion board. So, 3 responses to these questions. 3. All right? Not 1, not 2. 5 is right out. 3. So, we have 4 things that we're going to talk about today. The first one being mandatory arbitration clauses. And the simple fact is that it's clear from the cases and from the law that mandatory pre-dispute arbitration clauses are perfectly lawful, perfectly within Congress's understanding of its intent within the Federal Arbitration Act. Because every attempt by the administrative state to remove pre-dispute arbitration clauses from certain types of transactions has been reversed either by the Supreme Court, and so for that I'm going to point you to the case we talked about before Thanksgiving, the Epic Systems case related to the National Labor Relations Act, or Congress itself repealing the rule through the Congressional Review Act. And the book makes the point of the Consumer Finance Protection Bureau's rule at 12 CFR 1040 that was reversed through a Congressional Review Act proceeding. There are 2 exceptions to this sort of push forward of allowing more and more pre-dispute arbitration clauses. The first one is, as we've discussed a couple of times in class, the new law, whose name I can't remember, related to sexual harassment claims in arbitration clauses, right? That forbids the enforcement of pre-dispute arbitration clauses specifically for sexual harassment claims that came about as a result of the Me Too movement. And then the second piece of, the second type of claim where pre-dispute arbitration clauses are forbidden are clauses that purport to prevent private rights to enforce state policy. And this is specifically in the case that these statutes have specifically come about in California in relation to the Private Attorney General Act, which empowers individuals to act to enforce California law as if they were the California Attorney General. And the Supreme Court has held that California is allowed to do that, and that these claims, because they are standing in the shoes of the state, do not, in fact, require arbitration because the state has not agreed to arbitrate the claims. And so the contract is between the individual and the contracting entity, not between the state and the contracting entity. So private attorney general statutes do not trigger arbitration clauses. The second policy issue that we're going to talk about today relates to confidentiality. And the readings talk about this distinction between privacy, right, which is the right of participants in an arbitration to exclude non-participants from the proceeding, and confidentiality. And that's the right of participants in an arbitration to prevent disclosure of what happened during the arbitration. Arbitration is private. So unlike a court proceeding, random bystanders, journalists, whatever, they can't show up and observe the proceedings. But unless it's specifically contracted for, arbitration is not confidential, which means that whatever happens in the arbitration can be talked about. And the readings make a point that there's this balance that has to be struck, right? You have legitimate interests in not wanting your private business to be broadcast to all and sundry. And that legitimate interest doesn't just flow to big corporations that want to hide whatever malfeasance they're engaged in, right? That legitimate interest also extends to local, I have a helper coming in. It also extends to individuals that want their own, thank you, your help is not needed, sorry. It also extends to individuals who have interests in their own private information, right? That they don't necessarily want disclosed to God and everybody. And so there are reasons why you might prefer arbitration, particularly if you've bargained for a confidential arbitration. So, yes, even in the case of like a sexual harassment claim, where you have the right as a victim to seek your day in court, but you may prefer to tell your story in a private forum. And you're allowed to do that. And balancing those interests is really, really important. And I'm not convinced that we have the balance right yet. So that's one of the things that you may want to discuss on the discussion boards is what is the right balance between the interest of the parties in protecting their own private information and the interests of the public in knowing what and how these decisions get made. And finally, right, on the issue of privacy and confidentiality, the public also has an interest in legal development, right? We have an interest in seeing that new factual situations allow us to determine whether the law needs to change. And we can't do that if those new factual situations only ever get resolved in private. So, the third policy issue that we're going to talk about is the scope of arbitration agreements. It is a bedrock rule of arbitration that it is driven by consent. Okay? You're not going to be forced to arbitrate a dispute that you did not agree to arbitrate. And so, whether a given dispute falls within the scope of a given arbitration clause becomes really important. And so, you can absolutely write an arbitration clause so broad that it basically encompasses anything and everything that you may be asked to any dispute that may arise. But, if you choose not to do that, right? If you choose not to do that, if there are some disputes beyond the scope of the arbitration clause, then the question arises, is this dispute within the scope of this arbitration clause? Now, some courts, notably in the book, the Second Circuit, apply this threshold question of, is there a broad arbitration clause or a narrow arbitration clause? And this is the first question that they ask. And broad arbitration clauses are entitled to a presumption of arbitrability, right? The idea is, if you've written an arbitration clause so that anything and everything falls within it, then we should presume that anything and everything falls within it. If you've chosen to exclude something, then the Second Circuit says, well, now we have to get a little more, we have to look at what the actual text says. And Justice Gorsuch, who was not a justice at the time, points out, sitting by designation in the Hatemi case, that this is sort of nonsense, right? His argument is that we don't have to start with this threshold question because we can just ask, what does the arbitration clause encompass, right? Broad arbitration clauses don't need a presumption of arbitrability. They're broad enough to encompass all the disputes. And sort of the flip side of the coin, right? Narrow arbitration clauses are equally entitled to a presumption of arbitrability under the Supreme Court's policy favoring arbitration, right? The Supreme Court says that if you have any doubt as to whether the dispute is arbitrable, you assume that it is arbitrable and you send it to arbitration. And narrow arbitration clauses are just as entitled to that, where edge cases get resolved in favor of arbitration. Now, the exception to this is questions of arbitrability themselves, right? Is this dispute one that is governed by the arbitration clause? You can send those questions to the arbitrator, but you don't have to. And, in fact, the presumption flips in that case. Whether the dispute is arbitrable is a question for the court unless there is clear evidence of submission to the arbitrator. Now, one thing that I want to point out that the book makes a point of showing you is that the AAA rules create the presumption that the arbitrator decides questions of arbitrability. So if you're reading an arbitration agreement and it incorporates the AAA rules, the American Arbitration Association rules, you have now agreed to refer questions of arbitrability to the arbitrator. The last thing that we are going to talk about today is choice of law, because it's very common for arbitration clauses to say disputes arising under this contract will be decided in accordance with the law of this jurisdiction, right? And this is relatively straightforward. I say relatively because choice of law is never that straightforward, as you may know if you are taking federal courts with Judge Martin. But generally, if the contract says Kansas law, then we use Kansas law, right? It's not that complicated. A few hurdles that I think are useful for us to recognize for this course, right? Some jurisdictions will, specifically for tort claims, right? Some jurisdictions employ a doctrine called locus delicti for their choice of law rules. So you have a contract, that says we operate under New York law for this for disputes arising under this contract. You assert a tort claim related to the contract, and so it's subject to arbitration under the contract, but it is a tort claim. New York uses locus delicti for tort law claims, and so the contract is specifying that you use New York law, and New York law specifies that you use the law of the location where the tort occurred. And so if you have one of these cases coming out of Kansas, right, you have a contract that says New York law governs, and then you get to the arbitration hearing and the parties' briefs are filled with cites to Kansas cases, and you're like, what's going on? I thought New York law controlled. It's because New York uses the locus delicti doctrine, and because the claim comes out of Kansas, Kansas law would be used. The next hurdle, right, is that sometimes you have an arbitration clause that provides for a choice of law provision, and then after the execution of that arbitration clause, one or more of the rules of that jurisdiction get invalidated. And so, does the arbitration agreement require you to use the law that is in existence at the time of its execution, or the law in existence at the time of the dispute? And the DirecTV case says that the answer is the latter. We use the law that's in existence at the time of the dispute. And I think that raises some really important questions related to the consent of the parties and a meaningful meeting of minds. And so I think that's something that I would like to hear your thoughts on the discussion board. And the final choice of law hurdle is that what if the arbitration clause specifies a choice of law provision for a jurisdiction that flatly contradicts the Federal Arbitration Act? So, for example, the Federal Arbitration Act exempts workers engaged in interstate commerce from the enforcement of arbitration clauses. But what if FedEx creates an arbitration clause that forces its package handlers to arbitrate in accordance with English law, which does not recognize the commerce exception? Now, the reading only talks about this issue in the case of arbitrability. And that's the Cape Flattery case, which says that you absolutely can do this, but it has to be clear and unmistakable because of the presumption that arbitrability is reserved for the court. And And so, because of that, right, courts don't like to apply foreign law, they don't like to send arbitrability questions to arbitrators, and so they will apply federal arbitrability law to determine whether arbitrability is sent to the foreign law arbitrator. Whether that applies to explicit statutory commands related to the merits of disputes, that's a harder question. I don't know yet what the answer to that is. Maybe you guys can find out and post it in the discussion board. So, I want to say that I appreciate all of you who asked very kindly after Albie, as I took him to the vet on Friday. Turns out the little jerk was just sandbagging me. So we are going to go see his primary care physician just to rule out seizures and bladder stones, but he's doing fine. You may have noticed that he was the assistant trying to sort of push his way in during this lecture, and unfortunately he's left, so I can't grab him and show him off to demonstrate just how well he is doing. But all of you that asked after him, I appreciate it. He doesn't know. But if he knew, he would appreciate it, because he's a good guy like that. But I certainly want to say how much I appreciate everything that you guys have done this semester, all of the work that you have put in, all of the effort that you have expended, all of the time and energy and engagement that you have given me. And I am sorry that we're ending in this way. I have noticed that there's a couple of you that I'll see in the spring, and I'm looking forward to that, so see you then. For the rest of you, just because we are going our separate ways does not mean that our relationship is over. You can come and find me, anytime. I'm up in 314 in the law school building, and I will look forward to seeing you guys in the future. And for those of you that are graduating, congratulations, and I will see you at graduation. So take care, everybody, and please do answer 3 of the questions posed on the discussion board. Thanks so much.